this morning's docket. That is case number 110585, State of Kansas v. Thomas.
May it please the court, counsel, I'm Corey Call representing Eddie Thomas. Request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. Mr. Thomas was convicted of first-degree murder on a combined theory of premeditation and felony murder, and also of aggravated robbery. We raised 3 issues on the brief. The first issue is whether the district court erred in instructing the jury that it could convict Mr. Thomas on a combined theory of premeditated murder and felony murder. And it's not every day you can walk into court and ask the court to overturn 900 years of settled law, but here I am.
But the additional problem you have is also consistent with our definition of alternative means. Once we say these 2 charges are alternative means, then we've indicated that it doesn't matter. You can have a combined theory. So the fact that we make the jury tell us whether it's a combined theory doesn't really change the calculus that they're allowed to do that.
That's absolutely right. If I understand your question, if this court finds that premeditated murder and felony murder are alternative means of first-degree murder, then I lose. I'm saying that they are distinct crimes. And I think there have to be 2 premises.
And actually you're saying if we continue to say that there are alternative means, because that's the law. Right
Oh,
now.
absolutely. And it's been the law since Merry Old England. The reason I think that history is largely irrelevant is because the legislature has changed first-degree premeditated murder and felony murder and the dynamic between those 2 to such a degree that the previous connection has been stretched beyond the breaking point. And so there are 2 premises that I think you need to agree with me. I think the state might even concede that these 2 premises are right. Before we can even get into a substantive discussion, there are 2 premises. One is that the legislature could, if it wanted to, make these 2 distinct crimes. They have the authority to do that. Nothing in the history requires that felony murder and premeditated murder be alternative means. And second is that to determine whether they're separate crimes, we look at the substance of the 2 statutes. We don't look at because the legislature has expressly said they're not separate crimes, they're alternative means. But what they say and what they do are sometimes different things. And we need to look at the substance of the statutes to see whether they are, in fact, 2 different crimes. And if we can agree on that, then we look at what has the legislature done recently, and under the current statutory scheme, are they the same crime? And the 2 factors that I would point to mainly would be the difference in punishment and the recent change that sort of excising felony murder from the homicide tree of lesser includeds. On the punishment's important because if these are the same crime, they're just different ways of committing the same crime, then we would expect that they would be punished, probably the same, but if not, then similarly. And that's not the case. The legislature punishes these 2 different ways of committing the same crime drastically differently. Double, it's a hard 50 for the premeditated murder, hard 25 for the felony murder. And again, we should look at how does society view these crimes, the moral culpability of these crimes. And we judge that by what the legislature does, and we judge the effect of the legislature's intent by the amount of punishment that they ascribe to particular crimes. These are 2 very different punishments. On the punishment, and they've recently, when they bumped it up to a hard 50, for first-degree murder, they said that can be, you can have a departure. There can be certain circumstances in premeditated murder that you get a lesser punishment than what we say is the normal course. Not so with felony murder. It's a hard 25. We don't care what the circumstances are. If you're convicted of felony murder, you get the hard 25. That's what you get. And again, it shows a difference that the legislature is treating these as two different crimes. And the importance of the public perception of the moral culpability is important. But I think that the even bigger distinction came when the legislature removed felony murder from the lesser included scheme of the homicide tree, if you will. Prior to recent changes, felony murder was a lesser included of capital murder, and all other homicides were lesser included of felony murder. And the legislature changed that. They, as I see it, they said felony murder is different than all of these other homicides. And so we won't consider whether or not the secondary intentional is a lesser felony murder because it is different. And it creates some confusing situations. In this case, the jury was instructed on the lesser of second degree intentional and voluntary manslaughter. And I'm not sure if they're convicting on this Frankenstein theory, are there lessers? Can you consider lessers of the intermediate theory where the jury has combined premeditated murder and felony murder? Do lessers agree? Can lessers apply if you're considering that theory? Because you can't do it for felony murder and you can't do it for premeditated. Are some jurors allowed to consider lessers but others not? And these problems come up because they're separate crimes. The legislature has divorced the two crimes of premeditated and felony murder into two separate entities.
And what theory do we reverse or find the statute inappropriate or overturn the statute? Because clearly the statute says these are alternative means, the way it's set up.
That's right.
And they're both defined as the same crime. And we've said the legislature gets to define crimes. Even if it's ludicrous and it makes no sense, how do we give you what you want once the legislature defines that apples and oranges are part of the same crime?
Well, there's a couple answers, I think. The first would be the unanimity statute, that the legislature has also said that the jury must be unanimous as to a crime, and to the extent that in substance they define apples and oranges, then it's contrary to that statute.
But we'd still be rewriting the legislation that sets out what constitutes first-degree murder. I mean, I don't understand that. Would we somehow employ the unanimity statute to do what we can't do otherwise?
Well, I guess
I get the substance, but we just don't have the power to write legislation.
Sure, well, but you have the power to reconcile inherently contradictory statutes. And to the extent that they set out two separate crimes, and then they say, these are the same crime. Those are inherently contradictory. And it's this court's duty to reconcile that. And a guide to reconcile that is, well, what should you reconcile that? What other statutes are there? Well, there's the requirement of the unanimity, that the jury has to be unanimous. I didn't raise this in there because there's still some argument about whether constitutionally, whether unanimity is not just a statutory problem, but is a constitutional problem. And I raised this as an instructional issue because I frankly didn't want to get into, because there's some procedural hurdles in raising that, and I didn't want to get into that whole argument. But that's another avenue, is that it's a Sixth Amendment constitutional right to have it be unanimous. And I know the Supreme Court talked in Shad about this very issue, as far as the whether felony murder and premeditated murder had to be, whether the jury had to be unanimous on those alternative means. But in that opinion, they noted that the Arizona Supreme Court had found that they were alternative means and they were not separate crimes. And in that case, and they didn't revisit that because it was a state law question. So I don't think Shad is controlling here, because they deferred to the Arizona court on the exact question that I'm asking you to reverse.
But I think that makes the point. What I see as the fallacy of your argument in relying on the unanimity statute, which is that all comes back to whether it's an alternative means. And if the legislature has defined first-degree murder with two alternative means, it doesn't matter again, does it?
I would totally agree that with that statement of law, but I would say that their statement that these are alternative means of the same crime is at odds with their subsequent definition of the two crimes. And that what controls would be the substantive definition of the crime. That's what, the fact that they said they're alternative means, that doesn't mean anything if they don't actually then define them as alternative means. If this court, like I said, this court says that these are alternative means, we looked at the substantive, they're similar enough, because alternative means are going to be different, right? If not, they'd be the same crime. But if they're substantively they're the same and or similar enough to be alternative means, then yeah, I lose, because that law is clear, and I take no issue with that.
Let me move you to the second issue real quickly.
Yes.
Why doesn't Pantane and Phillips undermine your argument that the Miranda violation doesn't preclude or doesn't apply the exclusionary rule to physical evidence?
The question is whether or not the statements of Mr. Thomas were used against him in a criminal case. That's the Fifth Amendment. Our argument in Pantane, the officers were told information, unmirandized information, and they went and got physical evidence. That physical evidence comes in because the Fifth Amendment has its own exclusionary clause that says statements cannot be used in a criminal case. It says nothing about physical evidence, so it doesn't apply. But here, the officers used the statements to obtain a warrant. They used, just as if they went into court and testified, they used those statements in a legal manner in a criminal case against Mr. Thomas to obtain the warrant. So
we understand that. You're about out of time. We understand that, but Phillips said differently.
Oh, Phillips,
Why was Phillips wrong?
Because Phillips said that the distinction between the Fourth Amendment and the Fifth Amendment was irrelevant. And that was basically all they said about that. And it's critical as to whether or not, is it a Fourth Amendment? Did they commit a Fourth Amendment violation, or did they commit a Fifth Amendment violation? If this court finds that it's a Fifth Amendment violation and the warrant, it doesn't matter whether you do it on a warrant or not, then I lose. If it's a Fifth Amendment violation, this stuff comes in. I'm saying it was an improper warrant, therefore it was an improper search, which is a Fourth Amendment problem. And fruits of the poisonous tree apply to the Fourth Amendment. That's why Phillips is wrong.
Any more questions of counsel? Thank you, counsel.
Thank you.
May it please the court, the state appears by Stephen Elbermeyer. If I could, I'll briefly pick up on issue 2 and advise that the part of the statement that was suppressed involved the defendant being brought into the police station, taken back for an interview, talks about, yes, I was with Chris Dotson that night, and then into the interview admits to shooting the victim. And at that point, the district court judge suppressed because he should have been Mirandized was the ruling. So did the police, and if the defendant had testified at trial, that suppressed statement would have come in because you can't use the Miranda violation as a shield or sword if the defendant testifies. So is it misconduct for the police to put in the affidavit, well, we don't know if this is going to later be suppressed or not, this statement, so we'll just put it in here. I don't think that should be the standard, and that the Patain case is.
Well, but
got it
even
right.
if it comes in later, it doesn't change the character as being unlawfully obtained.
Well, Patain says as long as it's voluntary, it'd be unlawful because of the Miranda violation.
Right, and the distinction is that even under federal jurisprudence, if it's a coerced or involuntary, you can't use it, right, for a warrant?
Yes, correct.
And so my question is, when the police threaten to air out, quote, air out, end quote, his, quote, dirty laundry, end quote, why isn't that coercive? If they threaten to out him, that seems fairly coercive to me.
I think that under Patain, as long as if it's still voluntary, then the sanction is a violation of the self-incrimination clause.
But it's not, I guess my point is, it's not voluntarily if it's obtained through threats.
But the district court found that it was voluntary. It just got suppressed because of the Miranda, that the judge thought that Miranda should have been given when he admitted to shooting the victim. And so it's different from a coerced statement. And then I also briefed the fact that if you take that out, you still have probable cause in the affidavit where Thomas is the last person seen at the apartment not long after the victim has withdrawn $500 out of his ATM account. And looking at the other language in the search warrant, that would be sufficient.
Opposing counsel explained to us why he thought Phillips was not a proper extension of Patain. Could you explain why, in your view, apparently that it is? The 10th Circuit decision, Phillips?
Right. I think in the appendix to the blue brief, the district court set out that thought that that Phillips and Patain applied, that it's not that much of a bigger step from Patain than what Phillips did, because the purpose of if the self-incrimination clause is violated, then you're suppressing the statement, but evidence that comes out from that does not violate the self-incrimination clause. I think that was what was in the Phillips case.
Okay, that's your explanation as to why Phillips is an extension of Patain and a logical extension, therefore proper?
Yes. As well as again, I think the district court judge addressed that also in the opinion, which I would refer the court to. As far as the first issue, whether the jury instruction or verdict form was clearly erroneous, well, it comported with the law at the time, so it wasn't clearly erroneous. The argument really is that there should be a change in the precedent, a change in the law, and I think that one of the more recent cases setting out that felony murder and premeditated murder or alternative means was in the Morton case, and the jury there it was kind of similar facts where Morton goes into he's been fired, goes in and shoots somebody, and we don't know whether it's during the course of a robbery because he ends up robbing the employer, or that he's mad that he got fired and has premeditation. The court in Morton said that was enough as long as evidence of each means was sufficient. Instruction and conviction on combined theories was proper. And so to say that the district court judge should have disregarded Morton and all the cases set out in the PIC instruction would not really make sense.
Is the legislature free to define first-degree murder as it wants if it says, defines killing of a human being intentionally or with premeditation and the commission or attempt to commit felony murder, or let's say they included involuntary manslaughter? Could they do that?
I think they can define the crimes as they
wanted to?
Yes.
Even though that would be more distinct than what felony murder and first-degree murder might be, or premeditation.
It would be more distinct, but yes, I think they could do that. And as I see the argument, it's that, well, premeditated murder, or there's a case that says the felony murder portion supplants the malice of forethought part of the killing, and malice is no longer an element of premeditated murder. Well, I don't think that's really changed. I mean, you still have an intentional premeditated killing, so that argument.
But my question in that regard, if you're gonna use that rationale that the commission of the collateral felony replaces the premeditated intent, or whatever you wanna call it, malice, why are there different penalties? If this just replaces that so that they're both the same crime, why are they punished differently? And why do they have different lesser includeds or not lesser includeds? And why can you attempt premeditated and you can't attempt another one? We've said you can't attempt felony murder. So it doesn't look like they're the same crime when you look at the differences.
As far as the punished differently, the sentence, as I recall, the sentence for first-degree murder is life, and then you have the difference as far as parole eligibility. But
Is there any other crime that we have with alternative means that has a different punishment? And Aline, or however you want to pronounce it, made it clear that the minimum punishment is part of the punishment. That's a different punishment when the minimum is higher. So we do have different punishments.
well, and with the verdict form, when the jury said, well, some of us think it's premeditated, some of us think it's felony murder, he got the felony murder sentence as opposed to the.
But do you know of any other statutory crime that we have determined has alternative means of committing it that differentiates on the minimum or maximum sentence?
Well, most of your alternative means involve the different intents, I guess. Where here you have somebody who's shot, as opposed to like a rape by force or fear, or a rape by drugging somebody. So no, I can't think of something different like that. But so here we.
It doesn't make a lot of sense that you can attempt one of the alternative means and not another one. Right, or that you can get lesser included instructions on one of the alternative means and not another. They either are both the same crime or not. And I understand our problem of getting around, the legislature can say what the legislature wants to say, but it's certainly a bit nonsensical when you take a look at all those areas, isn't it?
I think so, and that would just be. I mean, the Berry case changed what was that it made it lessers of felony murder and premeditated murder, but the legislature changed that. But so yes, I don't know, but they still would. I don't think we should change the precedent that's been around for 800 years. On this case, especially when it wasn't presented to the trial court, and that we just shouldn't change our precedent, and the legislature has said it's alternative means.
Well, counsel, given some of these theoretical difficulties, I'm curious how you would respond, or what do you think is the proper way for to answer the interesting problem defense counsel raised when a jury like this one is presented with kind of the hybrid case? How are they to work through issues like lesser includeds? And how practically speaking, how is that supposed to happen?
Well, the lessers of premeditated would be given, which I think the lessers that were given were second degree involuntary manslaughter.
Right, but how is a jury supposed to
To
work
know
through
what-
that? Are they supposed to split into two? You know, and that's what defense counsel suggested, I think, rather tongue-in-cheek. What is supposed to happen? How can a jury resolve these inherent conflicts as it does its work?
Well, if they get a lesser, I guess the jury doesn't know that it's a lesser because of the premeditated alternative as opposed to the felony murder.
Right, so on review, how is a court supposed to review a verdict if a lesser comes back?
I guess just as far as whether it's a lesser, a felony murder or premeditated murder,
Correct.
I think you would look at whether there's sufficient evidence to support the second degree murder verdict or whatever the verdict
Well, but I
is.
think what we're getting at is it would be an improper conviction if those that were looking at felony murder that didn't think it was premeditated or weren't even considering that. I mean, you understand what we're saying? If you had felony murder and they convicted of a lesser, that would violate the statute that says there's no lesser. So how do we know whether they found that lesser of which alternative means? Because they weren't instructed that you can only find the lesser to the premeditated.
In this particular case, they weren't instructed that the lessers didn't apply to the felony murder. They were just told they were lessers of first degree, right?
That's correct. And I don't recall where Barry was in the trial of this case,
Right.
whether it was a lesser or
Yeah.
not. But still the elements, if it's an intentional but not premeditated killing, would that be sufficient evidence, I think would be the analysis.
Let me just see if I can recap for a second these last couple of questions so we can identify exactly where we are. I think your response to Justice Siegel was that if an appellate court is confronted with a situation where the jury was presented with a combined first-degree murder theory and it returns a verdict on one of the lesser includeds that we know, but the jury wouldn't know, was given only because of the premeditated theory, we would just review for sufficiency on whatever the lesser was of conviction, correct?
Yes.
Okay. And then I think my colleague, Justice Johnson, asked you about what if some of the jurors wanted to convict of felony murder and did not want to go to the lesser. Is that the essence of it, Justice Johnson?
And how do we know that?
We just don't have a way of knowing. That's the answer to that question,
that,
right?
That there was a disagreement. We already know here there's a disagreement on the
The
first.
first degree theories,
Right.
right?
And if some of them wanted to vote, but then acquiesced and agreed to the lesser, then actually their vote is legally incorrect.
We just don't, yeah.
We don't
But we just
know.
don't know. We don't have
don't
any way
know.
of knowing at the appellate level. I think that sums it up, doesn't it?
I think so, but I guess in that situation, you would just look as to whether or not there was sufficient evidence to support each
For whatever
Alternative.
conviction we get.
alternative means.
When there's a situation where someone who wanted to vote for felony murder conviction capitulates to a lesser included, we won't know that. Or if someone who wants to vote for a lesser included capitulates to pre-med because the others want felony, we have no way of knowing that at the appellate court level when a case is instructed as this one was. That's the upshot, right?
I think so, but I think there's a difference between alternative means and lesser included. And I think there's a jury instruction that says if you can't all agree as to the greater, then you have to go to the lesser.
Right.
So I see that as a little bit different, but But in this,
If there's a thumb on the scale, it's a thumb in favor of the defense, that's your point. If there's a thumb on the scale in that divided jury situation, whichever way it goes, it would be a thumb on the scale in favor of the defense. Because of that additional instruction that says if you can't agree on a greater, you go to the lesser.
yes, I guess so.
Okay, thanks.
Unless the court has any other questions, I would ask you to find that the verdict form was not clearly erroneous and that the evidence was properly admitted and affirm the defendant's conviction.
Any more questions? Thank you, counsel.
Thank you.
You reserved 3 minutes. You'd reserved 3 minutes for rebuttal, but it looks like you may be willing to waive that unless you have questions. Any further questions? I see none. Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. This time.